Okay, so thanks very much for joining us today. My name is Neil Websdale. I direct the National Domestic Violence Fatality Review Initiative in the United States for the US Department of Justice Office on Violence Against Women. We also do a lot of community risk work, a lot in Arizona, but a lot elsewhere too. So this is really a synopsis of some of the risk work that we've been doing over the last 10 years, really, in Arizona, this presentation today. And we'll have about 50 minutes for me to yak on, and then we'll take 10 minutes at the end to chat, to have some kind of dialogue about this. So this is a revamp of the presentation I was going to do when I was in Cambridge visiting Simon Kurz, but for some technical reason, we weren't able to pull that off. But so I want to talk about risk assessment and what we refer to in the States as community-informed risk assessment in intimate partner violence cases. So this is a controversial area, both in the US and in the UK and elsewhere. But I want to start by talking about some sort of operational definitions. I mean, when we talk about risk in these cases, we really have to specify risk of what. There's a very big difference, as we all know, between homicide, near death and injury, and severe reassault. All these are different categories of case, and things like injuries and severe reassaults obviously are much more common than the homicides, which are extraordinarily rare. The risk literature has developed around female victims, and so it should have done. This is where the bulk of the killings are. These are profoundly gendered, both by gender ratios, sex ratios of killing, but also by the microdynamics of the cases. So specifying the victim is important. The researchers focus on female victims. That's it. So this risk stuff doesn't necessarily apply to male victims because we don't have adequate N sizes in the research that's dug into those cases sufficiently well. So the same applies to children, agency personnel, same-sex relationships, gay, lesbian relationships, or trans relationships, or whatever. All of these relationships have such low N sizes. The research hasn't even gone there, and obviously it needs to in the long term. Then I think we also need to specify risk for how long, because we have limited resources. If we identify what we think is high risk, we still have to strategize about how we allocate resources over time. And I think the research is clear that risks are highest in the early stage after separation, or the inferring that a separation might occur in these potentially explosive relationships. That period from just the first 72 hours is a very intense period of risk, really running for the next, about half the killings occur in the next 3 months. So that's the window that we're looking at. And in terms of triaging resources, we have very limited resources. We have to think about risk for how long. And then we also need to think too about for which responder is the risk relevant here. Are we talking about police officers? Are we talking about victim advocates, batterer intervention program staff? Are we talking about emergency medical personnel? Are we talking specifically about the victim or the victim's family? So again, these are some of the things that we need to think about as we talk through this issue of risk. Risk assessment supposedly evaluates the degree of danger or threat. Lethality assessment, which is a different ball game altogether, evaluates the likelihood of a killing. We have to say from the get-go, and I've been saying this for 20 years from the research that I've been doing, we have very, very remote chances of predicting intimate partner homicides. They are so rare compared to the bulk of other cases that picking them, you're much better off on the roulette wheel in Vegas. I mean, these are remote possibilities. So statistically, this is very, very difficult indeed. So, and this is just to flesh that out. And I'm not going to read all this, but you can see from this slide that basically, if we have 15 million or so, assaults, physical, sexual violence, stalking events a year, picking out the roughly 2,000 cases in the US, where there'll be a homicide, this is just in 1 year, is just an absurdity. So these statements that we've got in the domestic violence field that we can predict, therefore we can prevent, are potentially misleading. But we'll come around later to see how statements like that, I think, came on the scene. And obviously they're very well-intentioned statements. But even Jackie Campbell, my friend Jackie Campbell, in her old preamble written 20 years ago, we cannot predict, she says, what will happen in your case. And her work, I think, in many ways has been misread by people in some parts of the domestic violence movement. My colleague Jill Messing and her associates have found that the lethality assessment protocol, when administered, is associated with, and that's the key word, not causing, but associated with, an increase in protective actions taken by victims and a decrease in the frequency and severity of violence among that sample of folks. And I think her N size there was about 619 based on data out of Oklahoma. Snyder et al. In a medical article posed 5 risk questions, and she says that 3 out of 5 yes answers indicates a high risk case. But in that section in that subsample of cases, only 25% of those high risk victims were subsequently severely reassaulted within 9 months. So that means that 75% of them weren't. Now we refer to this as low positive predictive value. And again, this is important if we're interested in rule of law and due process arguments about using these risk assessment tools in various contexts where they may come into circulation within the criminal justice system. So let me just say a few words about the types of risk, risk assessment. So we can have a clinical or a professional opinion perspective on risk. You know, so I could pose as someone who thinks he knows about these relationships and sit down with someone and listen to their narrative and give a professional opinion on whether the risk was high or not. This is almost kind of shamanistic in a way, you know, it's very problematic. And the numbers on this are clear that that kind of professional opinion alone is hazardous and not very effective at predicting outcomes. The better way to do it is through what we call actuarial or sort of almost like insurance company predictions based on clusters of statistical information that integrates these risk markers that we have. So we recognize the actuarial is better, but we also want to reserve a role for clinical judgment, especially for folks like victim advocates and police officers who work these cases endlessly and who sometimes have a sixth sense about how victims may be endangered. And there may be cues that they you know, feed off of that allow them to arrive at this assessment. And we want to include those perceptions in our actuarial. So we have what we call structured professional judgment. We combine the clinical and the actuarial in our method. And when we developed the Arizona risk instrument, which we call the APRAIS instrument, it's a form of community informed risk assessment. We factored this guiding principle in. We wanted both written into the paper trail and both written into the way these things go down on the street. So why the hell should we do this stuff? Risk assessment in general. Obviously, we want to create a shared language so we can bring people onto the same page. So, you know, in many ways, knowledge is power. And we want to inform decisions regarding bail, conditions of release potentially, supervision of offenders, sanctions, treatments, interventions. That was one thought that we had. Public education is also important, and awareness for legal social services. And we may add too, that if we add open-ended questions to any risk assessment, we're gonna get more information, but that may be potentially useful, but it may be potentially problematic in terms of working with victims within a criminal justice system where there may be inconsistencies in reporting factual information over time, which may lead to the impeachability potentially of someone's testimony over time. So these are things we wanted to consider. Reassuringly, there was a relative close correspondence between the research on risk and the findings of domestic violence fatality review teams. And I know the Brits have pioneered in terms of domestic homicide reviews. In my opinion, you do the best homicide reviews in the world. But when we look at clusters of risk markers, that's really where we begin to get some benefits, I think, from risk assessments. The Ontario Fatality Review Team, and Peter Jaffe, my friend Peter Jaffe, runs that initiative. He's been running it for years. But what they found in the early days, and they have tremendous amounts of information in those cases. I mean, we're talking about thousands of pages of documents. They found that 3/4 of their cases reviewed from 03 to 12 had 7 or more risk markers. And in fact, that number of 75% is now up to the mid-80s. So what this tells us is that clusters matter. Now we need to notice here, just the researchers on the call, that there's no matched control or referent group for this analysis. So in other words, there's no match of near deaths and what we might see there, or severe reassaults or something. So just that's a caution for the researchers. But the idea is that we're going to connect victims and perpetrators with services for social, for safety planning, etc. And we're very cautious. We're well aware that we can't say that services spell safety. They may not, but again, we don't have the data, we're evidence-based, so we want to be careful about even implying that. Evidence-informed. We know a lot more about female victims, as I said, and so we should. So what are some of the challenges of doing this, this risk assessment work? Well, obviously, if a risk assessment is done at a crime scene, which is one of our foci in Arizona, and as I say, we spent a number of years in communities developing this risk assessment with cops, with victim advocates, with focus groups of survivors. If we do it once, we obviously don't have the benefit of the fact that risk changes over time, we know. So longitudinal or rolling risk assessments are probably better than flat one-off risk assessments. So it's important to do these longitudinally. And that, of course, is challenging. The risk assessment, if it's just focused on criminal justice interventions, is obviously problematic. I mean, victims of violence need many, many more things than criminal justice interventions in their cases. They need housing, childcare, jobs, legal aid, et cetera, education services to move forward. So we recognize that focusing just on the criminal justice system is problematic. There is a potential problem of condescension and paternalism in that some expert stands there and says, we think you're at this risk and that risk. How we do that is important in the field. So coming across as not being condescending and paternalistic with this very specialist knowledge is a tricky road to hoe. I don't think that, in fact, I know that telling a victim she's in a potentially dangerous situation or very dangerous situation is not paternalistic. Telling the victim to leave the relationship obviously would be. But we have to strike this balance between being alarmist and feeding, you know, the emotional biographies of trauma that victims have, and trying to convey accurate information and to educate. So it's also important for us in Arizona when we do this to notify victims of the discoverability of the information that they might share at the scene if this is a law enforcement officer doing the risk assessment. That information, as we'll see later, goes right the way through the system and potentially does end up on the bench of the judge that does the initial appearance with the accused. And that information can inform bail setting, whether to release or whether not to release, and how to inform conditions of release for the offender pre-trial, if there is a trial, if there is a case, a criminal case. So it's important to notify victims of this and what's happening. We want to respect their autonomy. We want to respect their dignity. So when we started this work, and we spent 3 years in the field riding with cops in Arizona, trying to work out what they would work with in terms of doing risk assessments and what they objected to. And we were very candid with them. We said, tell us why the hell we shouldn't do this. Tell us why you don't want to do this. And there were many problems. I'll be candid with you. One of them was the time it takes. This is a pain in the ass. This, you know, these folks will whittle on about their, you know, their lives and this and that. It could take an awful long time to do this. If the officers are at the scene, there's a greater danger because the longer they're there, the more chance they have of being, for example, shot at a domestic violence scene. And in the US, long gun killings of police officers occur during domestic disputes. It's a common way that officers are killed in the US. So it's a big issue. So this was not something we could, you know, just bypass or ignore. What we would say is, give us the information, give us the evidence that you have that that's the case. And they didn't have that evidence. We don't have that evidence. But we just posed the question, well, could it be that those officers will be safer there in the future because we know more? And that was something that few of them had considered, but a good number of them came round to considering eventually that might actually be useful in terms of safety planning for officers as well, going into these scenes. Is there a resource to follow up with? I mean, if you're in Phoenix, I'm in Phoenix now. If you go to a domestic scene, there will be a victim advocate at that scene, accompanying, following up with the police officer. A serious assault, the advocate would turn up at scene, or it will be easy to transport someone to a shelter to get them services. In the small counties in Arizona, there are no victim advocacy services. So then you're looking at telephonic services or none at all. So this becomes very, very difficult. So let me say a few words about victim-perpetrator relationships that obviously impact the way in which we do risk assessments. Now, there's a tendency in the field to see this sort of, this relationship between abuser and abused as a simple binary. And we know this is, empirically, we know this is sort of nonsense. But, you know, we got this virtuous female protagonist on the one hand, and this one-dimensional male villain on the other. And this is very problematic because this channels us into various ways of thinking, which are, you know, if we just see this guy as powerful and controlling, and that's all we see, and the victim as, you know, the usual profile, then it limits what we can do. So we recognize, we've known this for 40 years, there's a lot of denial, there's a lot of minimization on the part of both parties. There's the appearance of dishonesty, if not outright dishonesty in these cases. There's witness intimidation going on. Sometimes there may be seeming complicity. The victim may appear to be complicit with the perpetrator or the accused's lies or interpretation or minimization of any violence or abuse. Victims come across, but perpetrators too, as having seemingly counterintuitive behavior for law enforcement officers or other rational, so-called rational actors who are responding to these cases. That gets confusing. So the risk assessment information that we get that's filtered through this counterintuitive behavior becomes very complex. We know that victims won't necessarily report abuse or leave or so-called cooperate with prosecution. We don't like the word cooperate. We, in the APRAIS, developed the language of declination, which means that victims just decline to cooperate because for whatever reasons, they haven't had a good experience with the state, or they don't think that's the best way to solve their problems. They fear losing their kids to child protective services. They have hope for the relationship. They still want to be with this guy. There's a stigma attached to divorce, and leaving is never easy. And then we also have perceptions of the indecisiveness of victims about leaving. So this too is problematic. Very judgmental in some ways, but she's concerned about losing home or father for the kids, etc. And then she's got to deal with his remorse. And then we come into this very thorny area, which gets more complicated. And I've been doing domestic violence homicide reviews now for 25 years at least. And, you know, I know from my interviews with victims sometimes, or particularly victims that have killed their abusers, that they will sometimes engage in taunting or potentially provocative behavior. This may appear to be victim blaming, even stating this fact. But the reality is that it's there in some cases and we have to deal with it. This may be deliberate. I've certainly had victims tell me I was winding him up or I was trying to piss him off to get a response from him. I was talking with a lawyer the other day on the East Coast, I shouldn't say where, who's working a case right now where a victim just literally goaded the guy to the point of him coming at her, ready to abuse her in the way that he had done traditionally and giving her the excuse with her gun ready and planned to shoot him. So, you know, inadvertent or deliberate taunting, provocation, that's an issue. And then we also have issues related to memory. You know, recall, if you've been whacked over the head a few times, your memory isn't that good. Sometimes people, what's called confabulate, their brain will actually put different information in. So this leads to problems with interpretation of the risk information, the consistency of the flow of the risk information, and the potential impeachment of testimony later. Offender behavior, we're really looking at what my friend Evan Stark refers to as coercive control or intimate terrorism here, Michael Johnson's stuff on intimate terrorism. These cases seem to be where the danger is. So the APRAIS tool and our community informed risk assessment, broadly speaking, was designed to identify those cases, those higher end cases where we're probably more likely to draw the homicides from. So distinguishing between that and situational couple violence, and I know this is a problematic binary too, but distinguishing between those two things is one of the goals of our risk assessment. Also recognizing, and I was talking with Simon Vincent earlier, I know he does some work with perpetrators, but in general, all perpetrators aren't the same, as we know. So we have the bulk of offenders, it seems to me, from my work in the United States, are what we call dependent intimate terrorists. They, underneath their bluster and their bullying and their power plays and all the rest of the things that they do, you know, they are very vulnerable. They are very dependent. So both of these types, the antisocial, the psychopathic intimate terrorist, is very different. And I would say that roughly, from my experience, about 80% fit the dependent intimate terrorist mold. The antisocial intimate terrorists are probably maybe 15, 20%. So how we deal with them in terms of safety planning and intervention is very different. And again, we've tried to operationalize that in the field, and we'll talk a little bit more about that if we have time. Both types are impulsive. They're accepting of violence as a way of getting things done. They're hostile towards women, and they've got very traditional sex role attitudes. So understanding this matters. And then the other thing I think we have to acknowledge is this paradox, is that survivors cannot discern the threat level. Even although we want to ask victims, survivors, thrivers, about the perception of risk, we have to acknowledge, especially when we go back and unpick from the homicides, that even although they can read his mood with sort of the sensitivity of a seismograph needle, as though a pending earthquake is coming down the pike, they cannot read the threat he poses. And it's the saddest thing doing these death reviews and realizing that, you know, victims did not know, and this is not to blame the victim, but these guys can be very secretive, extremely so, more so than we all can be as human beings. So I should probably just say a few quick words here about this sort of seemingly counterintuitive behavior of perpetrators. It makes safety planning difficult. Knowing that they're shameful, knowing that their violence is sometimes linked to their shame, their humiliation, their secrecy, their cunning, is important, but victims cannot know this. So our risk assessments are baselines, but we need to bear that in mind. And the safety planning that goes with this has to bear that in mind. Agencies and stakeholders also can't necessarily know. So our planning, I think, has to take this into account. I'm a great fan of James Garbarino's work, Listening to Killers, and also James Gilligan's work. These folks, Garbarino's a psychologist, spent a lot of time interviewing offenders. I've done some of this work, but these guys really have done a lot more. Most male killers are best understood as untreated, traumatized children who inhabit and control the minds, hearts, and bodies of adult men. For the dependent, vulnerable, serious DV offenders, this, I think, holds true. We're dealing with trauma with perpetrators as well. They've got serious trust issues, difficulties with intimacy, very high abandonment anxiety, and a rejection sensitivity that is sometimes off the charts. They're very sensitive to this stuff. They also may not remember their experiences. They may be amnesiac in that sense. So we're dealing with some difficult issues related to their childhoods. They may be hypervigilant. They may be on the lookout for things. So all of this stuff is relevant to how we deal with these things on scene. And when we train police officers, we talk about these things. If you're interviewing offenders, they may even engage in dissociative behavior. So I think that's about all I want to say on that, except that James Gilligan talks about the psychic annihilation of offenders. You know, they engage in preemptive strikes sometimes to protect their own psyches. So what are some of the characteristics of dangerous domestic violence cases? I think we know this, so I'm not going to belabor this. You probably know this better than I do, but prior violence and all these different things I've listed, victim perception of threat we've already talked about, separation in the relationship, the emotional estrangement, particularly when person's highly controlling and violent around those issues. Depression, suicidal potential is emerging as a new variable of some interest with some of the large data sets in the UK with the police data sets. Alcohol, drug use, excessive drug use, stepkids in the home, perpetrator humiliated fury, all these things matter. So having prepared communities in Arizona with this knowledge and a bunch of fatality review work from really 2004 through to 2014, we then set off to build risk assessment stuff from about 2010. So there are some statutory things that we need to look at, but we started our work in a county called Yavapai County, where we knew the chief of police, 2 chiefs of police were on board, the county attorney was on board, the leading legal officer in the county, the chief judge was on board. So we had a lot of support to do this. So this was a community initiative from the get-go, and we used federal money to do this. So there's a link between doing homicide review work and good risk work in Arizona. We recognized too in Arizona that we needed to share risk information, and we needed to get it to the court in a way that was legally viable, constitutionally viable, and in accordance with the strictures of due process. So I talked before about we needed to let survivors know what was happening with this information and the threat that that might pose to them if the abuser found out about that information, which is legally possible. So these were some of our considerations. We spent a lot of time with police officers talking about interacting with victims. And our approach is trauma-informed, and these are platitudes in some ways, just trotted out within the movement. This is very important though, linking the work we do in the field, that interface, with sort of a coordinated community response, particularly in more marginalized communities that have great suspicion sometimes of the state and law enforcement. So the methodologies prepare officers to interact humanely, recognizing that victims may be acutely traumatized, recognizing that they won't necessarily behave in ways that are conducive to typically a good exchange with police officers. So they may not behave in predictable ways. Questioning may trigger painful memories, etc. So we try to build all that in, and we do that in great detail in our training. And I don't have time to go through all that today, but maybe people that are interested, we can talk a little bit more about that. We want to take into account the counterintuitive behavior. Trauma comes in ways that sometimes none of us can anticipate. We obviously give victims the option to participate. They are asked, would you like to participate in a risk assessment? Because we think this might be helpful. We're concerned about your well-being, etc. We prioritize safety and choice, collaboration, trust building, and empowering victims. But, you know, again, this is difficult work. The single most important thing that we strive to do, and we have police officer trainers that do this. I don't do this work. I mean, I do the initial scientific introduction of things, but we have cops that train cops. That's our baseline. We know full well from years of doing this work, cops don't want to listen to some airy-fairy academic like me. They don't want to listen to women victim advocates. They just don't. They may pretend they do, but most of them don't. They'll listen to cops, and that matters. We hired cops to do this, and the cops are very good at it. But training them to be present, as if they're present with a family member and listening. We recognize that, and we had a number of young officers tell us this, we would ride with the cops and observe from a distance, and then they would talk to us about, well, she said no before the risk question was actually fully issued. And she said that 7 times. And we were concerned that this reflected not the fact that there was no abuse, but the fact that she was terrified. So the officers gave us this field information. The officers gave us information about body language and eye contact and side glances to see whether victims were concerned about the presence of perpetrators, etc., and whether they could listen. So we also built in, because of this field knowledge from cops, we built in what we called an officer discretion override box. And actually the Arizona Supreme Court weighed in on this as well. They wanted this included. So this is an important piece of statute law. It was around 2015, Arizona revised statute. I'm looking under 1 here, the statutory considerations. Arizona revised statute 133967 B5 basically refers to the release on bailable offenses before trial. The judge must take into account the results of a risk or lethality assessment in a DV case presented to the court. So in other words, if this information flows to the judge has to consider it. The weight that they attach to it is their own. You know, there's no exploration of the weight that they attach to this compared to other factors. But there are about 14, 15 questions that they have to consider when releasing someone on bail. And bail is a presumption under the 6th Amendment of the Constitution. So these are important issues. But the risk assessment informs a number of the other questions on there, and I don't have time to go through them all, but these are some of the questions that they may inform. For example, the nature of the offense, whether someone was using illegal substances or whatever. The APRAIS focuses on how we do the work, how we interact with victims, and how that forms part of a chain of case flow and interactions through systems that may result in the temporary, at least, incarceration of the offender prior to trial, but may result, perhaps even more often, we don't have the data yet, in specific provision of resources to offenders to help them change their behavior potentially, and giving them material supports as well as perhaps emotional supports, group support, and other interventions. So the APRAIS tool, and it stands for Arizona Risk Assessment Instrument System, really tries to work with the complexities of these cases. The basic logic is that past behavior is probably the best, although imperfect, predictor of future behavior. So the idea is to balance victim safety and the rights of the accused. And I have to say, this balance was something that the judges who worked with us, and there were a lot of judges, bestowed upon the project over the years. They said, if you don't get this right, there's no way these instruments are coming before the judiciary, and there's no way that the judiciary will heed this information seriously if you don't balance the two. So we spent a lot of time trying to balance this. And of course, some people criticized us for pandering to the accused. Others criticized us for weighing too much in favor of victim information. You know, it's a difficult balance to strike. This is not a perfect thing by any means. But it provides the APRAIS, if gathered at scene, and this is how it happens in a nutshell. You go to the scene, the officer administers the APRAIS after the investigation into the offense is complete. There may be a charge, the offender may be removed from the scene, or the offender may have absconded before the police arrive. They take the risk information, it's gathered, it's sent. Basically, if the offender goes to jail, the risk assessment is attached to the booking sheet that goes to the jail. When the offender, the accused, comes in the next morning to the court for the initial appearance, that information goes to the judge. And if there's a prosecutor and a defense attorney present, which there often is, then those attorneys get the information at the same time as the judge does, and everybody has open disclosure of this, you know, these allegations. Basically, that's what they are. But those allegations may or may not be accompanied by evidence of police report, photographs, injuries, etc., etc. So it just depends on the circumstances. The idea here is obviously to encourage the sharing of more information if victims so choose to go down this path. So the idea is that the initial appearance of the accused is to contribute information to the initial appearance decision-making. It's not designed to affect whether or not county attorneys charge and process cases, or it's not intended for information in the sentencing phase. Judges in Arizona are not allowed to take judicial notice of these risk assessments because they constitute allegations. So the idea is to provide more information with the full acknowledgement that the information is in the form of an allegation that may or may not be accurate, but that may warrant, you know, further follow-up. But it provides, in very dangerous cases where the judge is convinced that there's significant danger, the judge may deny bail or give very specific conditions of release that obviously remain cognizant of victim safety. So the idea is to provide intense services to both parties at this tricky juncture when the victim may or may not have decided to make a break in the relationship, because that break period obviously is a dangerous juncture. So we have two tiers in the APRAIS risk assessment. And I want to just say a few words about this, that the APRAIS was signed off by the Chief Justice Bales of the Arizona Supreme Court, changing the rules of criminal procedure. And what the Chief Justice did was, from 2018 onwards, April 2nd, say that the rules of criminal procedure are going to change so that we will recognize the APRAIS as the validated, scientifically validated tool in the state of Arizona. And we recommend moving towards a uniform adoption of this and following this intervention. So the idea was to unify, to develop a uniform intervention in these cases. Standardized, evidence-based information that may also inform other decisions in the court system. We're currently working on how we might introduce this information with evidence to back it up in the family court regarding custody, divorce, which obviously is still an explosive time. This is what this looks like. These are our top 7 questions, and we're grateful to Jill Messing for providing research on this, and Jacqueline Campbell, who was the originator of some of these questions. We know this isn't perfect, but this is pretty much an advance on what we had before. And a whole team of people are tracking outcomes to see if this works or not, if the outcomes are better. But you can see here an actual case that we scored yes to 2 or 3 tier 1 questions. And the tier 1 questions are mandatory. If the police department decides to go with this as a matter of policy, and there are 70 roughly in Arizona that are doing that right now, then they have to ask these questions at scene if the victim does not decline to participate. So you answer yes to 2 or 3 of these and you're at elevated risk. If you answer yes to 4 or more, you're at what we call high risk. This is the tier 2, which is optional, but what we found is that police officers in the field liked this so much, and it contributed to the detailing of their police reports, their write-ups, that they would ask tier 2 as well. The cops soon took tier 2 on as well, and it provided overall tiers 1 and 2, and provided a really comprehensive analysis of the case. Tier 1 is the predictive piece, which is imperfect, but nevertheless, it's the predictive piece. The most significant markers. You see tier 2 here, the kinds of questions that we're asking. So you may look at question 16 is the suicide question. I think the research is suggesting that we need to go back to our instrument here and elevate that question to a tier 1, but that's to be determined. So the officer at the scene has some choices here. The officer refers the victim based on the responses to the tool. So if in that tool that I showed you, there were 5 yeses, it's a high risk case, the officer refers based on that assessment. It's an actuarial assessment. But there's also a box just below the one that's ticked or checked there, victim referred for follow-up based on the officer's professional judgment. So if the officer gets all no on 7 tier 1 and 11 tier 2, but they still have this inkling, this sixth sense that there's danger, that their training tells them that they're seeing trauma, they're seeing intimidation, terror. We want them to check that box, even although we know that their clinical judgment often doesn't pan out in the future in terms of an outcome. We want them to check or tick that box. We don't want them to write additional material there saying, I think he's going to kill her. Because if you do that, it puts the judge in a very difficult position, because the judge has no empirical evidence from the 18 markers, but they've still got the statement, I think he's going to kill her. So it becomes tricky. And then there's a no referral as well, if this is a case where it doesn't seem that there's a risk at all. So this is what this means in terms of risk. If you're in the elevated category, the 4th bullet here, as a victim, you're 6 times more likely, if you're in elevated risk, of experiencing severe reassault or near lethal violence when compared to those who answer fewer than 2 yes. So if you answer 0 or 1 yes, compared to someone who answers 2 or 3 yes, the person who's in the elevated risk category is at 6 times greater risk. If they answer 4 or more yes, it's 10.5 times greater risk. This is relative odds ratios compared to people who answer 0 or 1. This is very important. So the judges in our work were emphatic with us. We know that you cannot predict outcomes. So you must state both relative and absolute risk. And if you look at the medical literature, public health literature, they all agree. We have to state both in the interests of the rule of law and due process. So the victim that answers 4 out of 7 has this 10-fold greater risk. And it sounds really alarming. They have a 10.5-fold greater risk of experiencing severe reassault within the ensuing 7 months from the presenting offense. But in terms of absolute risk, only 15% of those will actually experience that outcome within those 7 months. So what a defense attorney might argue, and defense attorneys are critical to our work, is that my clients in the 85% that won't do that. So you can see how we have to weigh both here. So 85% did not. If the outcome measure is just severe reassault alone and not near lethal violence, then that positive predictive value goes up to 23%. But either way, 15% or 23% is not particularly good. So we can't predict outcomes. But the third bullet here is perhaps the most important bullet that I have on this slide. If you take the cases where women experience near lethal violence within 7 months of the presenting offense, if you take all of them, the APRAIS tool would have correctly identified 95% of those. That's where the tool is particularly useful. And that's where you might make the statement, this has some statistical power. A coin toss would only give you 50% of those. So both statements are accurate. We want to hear both for the fair justice implications. And in fact, the Supreme Court was so adamant about this that attached to the risk assessment, the APRAIS form that the police administer is an explanatory document that explains the relative and absolute risk ratios and also contains reference to the research on which those calculations were based. So we feel that this is in the interests of full transparency and full disclosure, so that attorneys, prosecutors, defense attorneys have access to this information. And if they want to pursue it for court purposes later for trial, then they can. So the idea is that we value victim choice and that we also temper, if we can, the tendency to alarm and feed any paralysis on the part of victims in terms of their experiences. But risk assessments, closing thoughts, are not evidence. The courts must adhere to the statutes. So they may rise to the level of evidence with other documentation, but as allegations, they're not specific evidence. But what we hope happens is that this opens up a way of encouraging people to bring evidence, especially in the family court arena, to support their cases, even although this has to be done obviously in accordance with good safety planning. So risk assessment shouldn't be used as the basis for issuing protective orders or determining guilt or innocence. That's not what they're designed to be. The risk assessment field is in its infancy, and we need to use great caution. There are some real charlatans out there who are talking about, we can predict this, we know this, there are stylized patterns in these cases, of which there are some, but we have to be really careful. And I don't think we can take the extant literature for granted and assume that it's correct or authoritative or valid. I think we have to be veering on the side of safety much more and caution. So that's it for today. We have, I don't know, 12, 13 minutes for questions. I'll turn it open, Ray, for comments or questions if people have any, or if anyone wants to jump on.
Yeah, of course. And I'm going to give it an opportunity for people to go ahead and type in the chat feature if you would like to. It's in the bottom here, or that Q&A feature. Both options will allow you to pose a question to Dr. Neil Websdale. We do have one question right now, Neil, if you would like me to read it to you.
I can pull this up.
Yep, the Q&A section. If you click on the Q&A on top.
Q&A on top. Okay, got it. This is from Lou Marie. You mentioned the APRAIS is community informed. Can you please share the ways in which community engaged in this process, and also which communities were engaged, i.e. marginalized, underserved, law enforcement? Okay, great. So thanks for the question. It's a terrific question. So the communities that were engaged in this were the communities in Yavapai County, particularly Prescott and Prescott Valley. They were our laboratories, if you like, for doing this work. So those communities, Prescott tends to be economically better off than Prescott Valley. Prescott Valley has more racial ethnic minorities, particularly Latinos, Hispanic community, much more pronounced in those communities, more working class folks in those communities. We worked with the judges, the prosecutors, the defense attorneys, victim advocates. We spent 3 years in the community doing focus groups, particularly with law enforcement, particularly with squads of patrol officers, where the pedal really hit the metal in terms of, you know, how we were doing this work. We spent time in shelters. We spent time in focus groups, listening to battered women. And I think more importantly than that, we had a coordinated community response team that we worked with for 3 years, and there were 83 members of that group, and that's still in existence, but it was from all walks of life. And just to give you an illustration, when we came to arrive at the number of questions that law enforcement were going to ask at scene in Tier 1, I shared with them the information from Peter Jaffe's stuff in Canada about 7 risk markers being present in 75% of cases. The cops had refused to ask 20 questions, Jackie's full danger assessment. They'd refused to ask 11 questions. They said it was too many. But when we raised these issues and we discussed it, I said to the cops, you know, what the hell would you ask? What would you ask at scene? And they said, we'd ask 7. We could live with 7. So, and that's a very long story short, but we, you know, that was the negotiation around all of this stuff with all these different community agencies. So it was 3 years of what the researchers like to call ethnography. It was problematic. It was conflictual. It was difficult. It wasn't always enjoyable. We got challenged. I was personally embarrassed a number of times about my own ineptitudes, but that's the way it is. You know, you do this work. So I hope that answers your question, but email me if not, and we can talk some more about that. How is this?
Couple,
sorry,
yeah.
How is this risk assessment different from the ODERA? I could do a separate webinar on that. So all I would say is that the ODERA has a broader range of questions that are less specific to domestic violence. It doesn't mean their predictive value is any better or any worse. I think the deployment at scene is different. The state of Vermont, I believe, has used the ODERA and has a similar mechanism for getting it to the courts, but I could be wrong. This is a question from Simon Kurz. Welcome the statement on the need to better understand the neurobiology of perpetrators. How do we work this factor into domestic homicide reviews? Wow, that's a great question. I think that our biomedicine is moving to recognize the damage, for example, of lifelong trauma, is moving to recognize the damage caused by physical traumas like head injuries. So I think that our homicide reviews need to be asking questions about these various traumas. So I think that's really all I could say about this at this point, but I do think that we have to adopt a sort of biosocial approach to this stuff. I've interviewed too many offenders who've killed who clearly have biological damage. And that's not to say that biology is at the root of this. Clearly there are social factors too, but they're all important. I'm going to move on to a question here from Joyce. Have you used the APRAIS in civil domestic violence cases in which restraining orders are present, or only criminal cases? That's a great question. It's mostly used in criminal questions, criminal cases, before the judge at misdemeanor level. But I do know that some county attorneys are using them for charging decisions. We are not using them formally in the civil arena, we are exploring ways to open up cases to accept these risk assessments with accompanying evidence in custody, child custody disputes, divorce cases, paternity suits. But we're in the infancy there. And as you well know, Joyce, that's a hugely important area where we see a lot of conflict and homicide and violence. So the answer is primarily at the misdemeanor level, in the flow of cases through at the magistrate level, in the courts in Arizona. This is from Fiona Hunt. There are other risk assessments trying to do the same thing. The DASH, stalking and harassment form in the UK. Is this one better, or do you think any assessment is better than none? You know, I can't compare this to the DASH. I had a cup of coffee with Andy Myhill, who does a lot of work with the DASH in England. And I think in some ways they're apples and oranges. And I just don't know enough about how the DASH is operationalized. I understand the 27 question stuff, and I get the comprehensiveness of it, but I don't think it's pitched in the same way at the criminal justice system as the APRAIS is. So comparing apples and oranges, I don't know. I think the jury is out, and I think we'll spend the next 10 years, way beyond my career, trying to work out which ones of these work. Do I think that any risk assessment is better than none? No, I don't. I'm very guarded about risk assessments. I think we need evidence-based risk assessments. So if they look promising and they're well informed by the research, then they may be good to go. I think the risk assessments that are done with victim trauma, multiple forms of trauma and perpetrator trauma in mind, and are worked as part of a coordinated community response, that are culturally and racially sensitive, I think these would be good risk assessments, and yes, they would be better than none. But I think there's a set of ground rules here that we've learned over 20 years that we all remain cognizant of. So I think with that, we're getting fairly close here, Ray. I don't know if there are any other questions. We have time for maybe one or two more.
Yeah, I don't see any questions in the Q&A, but I did have a question about the training and how we were able to do training outside of Arizona State regarding the APRAIS. So if you can speak a little bit about that, it would be interesting to hear.
Yeah, sure. We are currently working with a number of jurisdictions in the United States to operationalize the APRAIS. They've expressed interest in this in part because our trainers are multi-agency, multi-professional. We have a team, defense counsel, prosecutor, a judge who handles these cases regularly, myself as a researcher, Greg Gianjobe as our law enforcement lead, and we have a victim advocate on the team. So there are 6 of us that go to a community. In fact, we're doing one in the autumn, where we go to a community. That community has to have some kind of funding. So in the United States, maybe that has an Office on Violence Against Women grant. They've been marvelous about supporting these initiatives, or some other source of funding, because obviously we have to pay for these people to get there and be there and do follow up and train and everything. So there is a cost attached to that. We're a university, we're not allowed to make a profit, so it's not like we're profiteering, but that's how we do it. Internationally, we've had some interest in this as well. But as I say, I think it's in its infancy. I think it's potentially powerful. And you know, for the money that you'd spend doing this, it's a fairly good intervention, but you have to be prepared. The community has to be ready. And we have to have an appreciation of the way these cases flow through systems. And if you're training law enforcement, my honest feeling after all these years is that you have to have law enforcement officers taking the lead on it. It's a thing for cops. If you're going to change cop culture on DV, then you have to have cops doing it who are well informed in the microdynamics.